Namaste, I'm Dr. Sapna Ghelot and my session is on the legal theory of rights. This theory, the legal theory of right, is opposed to the theory of the natural rights. It holds that the state is a source of rights. Rights are neither a gift of the nature nor do they inhere in the nature of man. They are created by the state. It is the state that defines what rights are. It provides the list of fundamental or legal rights. It upholds these rights and set up machinery to enforce them. It can alter or abolish rights if and when it deems proper. No rights can be claimed against the state. In the theory, in the writings of of this theory, we can say there is a Thomas Hobbes, but the greatest exponent was Bentham. He believed in the legal theory of sovereignty. Obviously, the absolute sovereignty of the state and the absolute or inalienable rights of the individual cannot go together. The importance of this theory. The legal theory of rights cannot be dismissed lightly. It is right when it says that the individual enjoy rights only if and when they are recognized and enforced by the state. Rights have no meaning if they are either ignored or opposed by the state. The claims of the individual which are not guaranteed and enforced are the best moral ideals. They may be called raw material of rights, but they are not rights in the correct sense of the term. Now, criticism of the theory. The theory is criticized on many several grounds, like it is said that it supports the concept of the absolute sovereignty of the state. It justifies the interference of the state in every sphere of man's life. It tears away the very foundation of individual liberty. Secondly, it is argued that the law does not create rights but only recognizes them and protects them. These rights themselves exist whether they are thus legalized or not. They are enforced because they are rights and are not rights because they are enforced. Next, the theory absolves the state of all moral obligations. Whatever the state would do would be deemed to be moral. No law of morality would be binding on it. In fact, morality must be the basis of rights. The individual should have those rights which are essential for his welfare and that of the community. It is a duty of the state to recognize such rights. It means that the state itself should obey the principles of morality. Lasky says that the justification of the existence of a state is the maximum number of rights it confers upon the citizens. Fourthly, if law be made the basis of rights, then a system of right would not be stable. The laws of a state are subject to a constant change. Often, the power in a state is captured by groups and individuals who use it, then its own selfish ends and encroach upon the rights of their opponents. The legal theory of rights would have justification to such encroachment, and the victim of the political operation would be morally disarmed. So, आपने देखा the legal theory of rights and उसका वैल्यू रहा इसकी what is the value of this theory, the importance of this theory, the criticism of the theory, and after the legal theory of rights हम देखते हैं the historical theory of rights. According to the historical theory of rights, rights are the result of the historical evolution. They are crystallization of customs. Customs occupy an important place in the life of every community. In ancient times, rights were everywhere based on customs. If in the course of ages, every community developed certain customs and traditions for the common good. These customs ultimately took the form of law, which became the basis of individual rights. In the end, these rights came to be recognized and enforced by the state. Thus, it is a history that makes rights. The state only recognizes and protects them, it does not create them. We often find that those rights which people think they ought to have, just those rights which have been accustomed to have, or which they have a tradition of once possessed. So, what is the criticism of this theory? There is a grain of a truth in the theory. No doubt several of our rights are rooted in the customs. For example, the right to freedom of conscience in India can be traced back to the dawn of our civilization. Similarly, people in England in the 17th century fought for rights which were customary. A custom which people go on following generation after generation provides a basis for law and rights. But the theory does not explain the origin of all the rights that people enjoy in any democratic country today. In ancient and medieval times, the authority of the government used to be a monopoly of certain privileged sections of the community. The majority of the people possessed no rights. The very concept of universal human rights was non-existent. The ideas of equality and liberty were unknown. Even slavery was justified as a natural institution. In some civilizations such as Christianity and Islam, even freedom of conscience was not recognized. Our own society before the inauguration of the constitution was frankly based on inequality. So, जो Harijans and women had an inferior status to that of the caste Hindus and men respectively. In fact, the very concept of the individual right is modern. It had its origin in the philosophy of individualism and democracy, which consider the development to be an end. This is hardly any right in the list of the fundamental rights embedded in our constitution, which can be traced to any ancient or medieval custom. Even the right to religious freedom was denied to non-Muslims during the medieval period of the history.